Hi, my name's Gib Irons. I'm a family law attorney practicing in Greenville, North Carolina, and the name of my firm is Irons and Irons, PA. Today I wanted to talk a little bit about child custody disputes and how to resolve them. And more specifically, I wanted to talk about the difference between different legal documents. A lot of people are confused about what type of document do I need to resolve my child custody dispute. So for example, the parents have decided upon a custodial arrangement. So mom and dad have decided this is the schedule that we want for the children, and now they're just trying to memorialize that schedule in a legally binding document. So there's two common ways of doing that, and one of those is by entering into a separation agreement that includes a parenting plan. That's very common. A separation agreement is probably the least expensive way to handle a divorce, and therefore a lot of people use separation agreements. Separation agreements can address all the issues incident to divorce. For example, child custody, child support, post-separation support, alimony, equitable distribution, attorney fees, all the various claims incident to divorce can be resolved in a separation agreement. Another common legal document that people use is a court order. And a court order can be one at the end of a child custody trial, the judge will enter a court order, a child custody order, but parties can also enter into consent orders by filing a friendly complaint at the courthouse and having the attorneys draft a consent order for custody. So the real important takeaway from this segment is what's better for me and what's better for my circumstances, and do I want a separation agreement or do I want a child custody order? And I think people need to consider more than just price in terms of legal fees when they make these decisions. So let's talk a little bit about a separation agreement. A separation agreement, as I stated before, has the benefit of being a less costly way to resolve a divorce situation. Now, the differences between a separation agreement and a consent order really come down to two things. The first is enforceability. Enforceability is if you've got a separation agreement, the way to enforce it is to file an action for breach of contract. And that can get kind of hairy when you're talking about issues related to child custody. For example, if let's say that we've got a valid separation agreement which says that neither party shall have overnight guests of the opposite sex in the home during their custodial periods when the children are present. If one of the parties violates that provision, then the moving party, the party seeking to enforce the separation agreement, would have to file an action for breach of contract. And the forms of relief are limited. The court can basically tell the parent not to do that anymore, but there's not real strong penalties that come with it. On the other hand, if you got a court order, then a court order is enforceable by contempt of court. And the moving party trying to enforce that same situation would have the ability to file a motion to show cause and an action for contempt, and the court has a bunch of remedies available, including the ability to admonish the party that's at fault or in violation rather of the agreement, to fine that party a monetary fine, or the court can incarcerate the party. So when we talk about contempt carries with it those penalties that you don't have in a breach of contract action. So I am frequently encouraging my clients, let's file a friendly court action, a friendly complaint, and let's enter into a consent order for custody as opposed to doing a separation agreement. And one of those reasons why I advise that is because of enforceability. So we've talked about enforceability. Now let's talk a little bit about modifiability. I recently had a case where the husband and wife, mother and father, had resolved all the issues related to child custody in a valid separation agreement. And they spent thousands of dollars with attorneys negotiating the separation agreement and came up with a parenting plan and a custody schedule, and they memorialized that in a separation agreement. Well, the separation agreement was supposed to be incorporated into the divorce decree on the date of the entry of the divorce judgment. But that never occurred. At the time of the divorce filing, one of the parties moved to incorporate the separation agreement into the divorce decree, and the other party objected. And it's well-established law that the court cannot incorporate a separation agreement unless it has the unqualified consent of both parties at the time that the separation agreement is being introduced or moved, the parties moving to have it incorporated. So the court denied one party's motion to incorporate the separation agreement, and the other party filed a custody action. And the court at that point, the court was forced to make a determination regarding the best interest of the children, which is the legal standard that we use in child custody cases. The court had to make a ruling, an initial child custody determination, and the court really couldn't give any weight, let's say, to the parent that had custody under the separation agreement. So despite the fact that there was a valid separation agreement, the court heard the case as a matter of first impression, and the court, considered the circumstances existing at the time of the filing. So that case right there is a wonderful example of how a separation agreement really doesn't have the teeth that a court order does. If on the other hand, the parties had a court order, a child custody order, then the moving party challenging that order would have had the burden of proof to prove that there had been a substantial change of circumstances affecting the welfare of the minor children since the entry of the prior order. So that is a higher burden. That's a more difficult evidentiary burden than the best interest of the children standard. So when moving to modify a legally valid court order, there's a higher burden of proof. So those are a couple of the reasons why you might consider requesting that your attorney draft a consent order for custody. Even if you all are able to settle your case without having to go to court, you still may want a court order just because of the reasons we discussed today, which is enforceability and modifiability. Go to our website at ironsandirons.com if you have any more questions, or give us a call at 252-215-3000 if you're in need of our assistance. Thank you, and look forward to talking to you soon.